Hi everyone, my name is Bob Percifield. I am the Chief of the Juvenile Division at the District Attorney's Office here in the H Judicial District. Wanted to chat with you a little bit about kind of the court process and some of the resources that we use for juveniles who have committed crimes in our community. As you've probably heard already, we have a very prolific diversion program. Approximately half of the cases that come to our office from law enforcement are referred to our diversion program. What I'd like to chat about a little bit are the kids that don't go to the diversion program. Typically those are kids where there are much more serious charges, or juveniles who have had one or two times already through the diversion program and need a little more supervision or help. Typically what that looks like is when a charge comes in or a kid is referred to court, we would file a petition in delinquency. It would open a court case, and the case would then proceed through the court process. The majority of the cases that we see that are filed end up resolving through some sort of plea agreement. Typically, if it's their first time through the court process, most of the juveniles are given what's called a deferred sentence, which is similar to diversion. So even if they don't get diversion and have to go to court, we still give them a chance to have what's called a deferred sentence. Now, a deferred sentence is a sentence where the juvenile would admit that they committed some sort of violation of the law, but instead of adjudicating them at that point or convicting them, which would be the adult version of an adjudication, we would defer making that decision for a period of time. During that time, they'd be supervised by the probation department. They would have terms and conditions they would have to follow, maybe some community service, counseling, things of that nature. And if they successfully complete their deferred sentence, their guilty plea is withdrawn and the case is dismissed. So in essence, it's similar to diversion, it's just with court supervision. Now certainly we have a handful of juvenile cases that don't qualify for a deferred sentence, or they violate their deferred sentence and they end up being adjudicated to be a delinquent. Again, many of those cases are still left in our community. Those juveniles are not committed to the Division of Youth Services or sent to prison or anything like that. Many of those kids are then given the chance to actually be on just what's called regular probation, where they again have access to all the resources that our community can provide to them through probation and other agencies that qualify. We have a pretty low number of juveniles that we actually end up committing to the Division of Youth Services. And in those cases, those are typically kids that have committed some either very serious crimes, or they've committed a number of crimes over a period of time, and have basically gone through all the resources that we have in our community to safely keep them here without committing more crimes or creating more victims in the community. Now, the Division of Youth Services itself, it's not like sending an adult to prison where they're basically on lockdown 24 hours a day. The Division of Youth Services is also a very treatment-rich program. They're juveniles that are committed to the Division of Youth Services have a case plan put in place by their case manager. They have education, they get counseling. There's a program that basically sets them up for reintegration back into the community. And so they're not sitting in a cell the entire time. The new legislation that's come out, Senate Bill 19-108, basically limits the number of kids or the type of kids that can be detained to kids that basically pose a serious risk of harm to the community, or juveniles that are a flight risk from prosecution. We don't typically see a lot of flight risk juveniles from prosecution, so that really leaves the number of kids that are going into detention as those ones that potentially are posing a serious threat of harm to someone in the community. That's a change from in the past when kids could be detained for being a danger to themselves. That's no longer allowed. The number of kids that we actually detain over the last year and a half really has diminished, and that's sort of a national kind of trend as well. Luckily for us, Larimer County has been really on the front edge, and even Colorado's been on the front edge of really toning down the numbers, or lowering the numbers of the kids that we actually detain, and trying to provide a more community-based service for those juveniles that are committing crimes in our community. So at this point, especially with COVID, the number of beds that were allocated at the Platte Valley Youth Services, which is the detention center that we use, currently we're at 7 beds. And if we need to borrow a bed from another jurisdiction, we can do that. I don't know that we've actually done that. We may have done it once in the last 10 months since COVID started. But it's very rare. Typically, we're running around 5 kids potentially in detention. Some of those kids are have some very serious crimes. We have a couple of juveniles in that are being charged with aggravated robbery, things of that nature. So typically those are the kids that are sitting in detention. We can also use detention as a sentence for crimes when a juvenile, say, can't complete probation successfully, but it's a lower level crime. We don't want to commit them to the Division of Youth Services, and so the magistrate has the ability to sentence those juveniles to up to 45 days of jail as basically the sanction for their crime. Once they're done with the sentence, they're released and they're done with their case. There are a number of cases that aren't eligible for diversion. Those cases typically include juveniles who have used a handgun or a weapon during the commission of a crime or commit a crime of violence. Crime of violence is something similar to like a first-degree assault, second-degree assault, murder, attempted murder, aggravated robbery, things like that. And so those juveniles aren't eligible typically for the diversion program, and those are the kids that end up getting filed into court. A lot of times, again, we look at doing some sort of deferred sentence. The one thing that we really have to focus on in cases like that are the victims. We have a lot of juveniles that are committing crimes where they're creating victims, and the Colorado statutes provide those victims with certain rights, and we have to be cognizant of those rights and make sure that we're taking those into consideration when we're determining where in this process a juvenile is going to fall. A lot of the diversion cases do have victims' rights cases or victims in those cases, but we do, as the DA's office and the diversion program, reach out to those victims, touch base with them, and see kind of what their preference would be, what they would like to see happen with the case. And many times, the victims or the victims' families want to see the juvenile offender, basically get counseling or get some services in place so they don't create more victims. There are certain cases, again, crimes of violence, where we certainly have to take that in consideration and there are statutory requirements that we have to fulfill. So one other advantage that our juveniles have in this state is some of the newer legislation that's come about in the last few years with regard to the expungement of cases. So even juveniles that aren't in diversion or don't go through the diversion program but are sent through the court system and are put on probation, once they've completed their probation sentence, there's a lot of new statutes and laws in place that allow for automatic expungement of those cases. On some of the bigger cases or more serious cases, the juvenile would have the ability to petition to have their case expunged, which basically would leave them at the end of the day with no criminal history. So moving into adulthood to apply for colleges or jobs or things of that nature, the case technically then would not have existed, and they successfully completed it. The case gets expunged, and so there's really no record of it anywhere for them to have to report in the future. And so that's definitely an added benefit for even those juveniles that maybe aren't successful in diversion or weren't successful in a deferred sentence and then are supervised on probation. And even some of those cases that where kids end up getting committed to the Division of Youth Services, at some point they potentially would have the ability to have those charges and cases expunged as well. So there's a lot of different things that are in place now with the statutory laws that are coming into effect that really provide every benefit and every opportunity for a juvenile to hopefully get the services that they need, the counseling that they need, so that they can move into adulthood and be successful, productive citizens without the decisions they made as a juvenile following them and hindering their ability to be successful.